in the court this morning. And as I was speaking earlier before my producer walked in to tell me that justice is already, according to the arguments put forward by the plaintiff, counsel representing the plaintiff, is that this is not about the limit of the powers as entrenched in Section 38A, but it is about when that power can be exercised. Looking at the fact that the requirements have to be present for there to be a triggering of that particular section on the election.
The Honorable Mr. Justice of the Supreme Court of Sierra Leone, the Honorable Mr. Justice Sani Sisi, Justice of the Supreme Court of Sierra Leone, and the Honorable Mr. Justice Ansumana Ivan Sisi, Justice of the Court of Appeal.
Please call who appeared.
I hope to begin and say the representation for the plaintiff is passed on the hearing.
Thank you.
Now, representation for the Attorney General and Minister of Justice remains to say.
Plaintiff present. Electoral Commission.
The plaintiff is present. The Chief Electoral Commission.
Plaintiffs.
Sorry, the second defendant is here.
Let me go step by step. Are the plaintiffs present? First plaintiff. Second plaintiff. Defendants. First defendant. Present. Second defendant. Present.
That this time we are put on the left-hand side of the bench. And the hearing will be on the right-hand side.
You are correct with this.
I thought as much, but I've been in this court when they spoke of over, and I demonstrate, especially in the jury trials, which it was far away from the jury. But it's not for us to say how it should be done. But this time, I have to work in place at the end of the day.
You were not present at the last hearing when I mentioned it. But I did not want to cause confusion. So it's noted. This is judgment of the court. By originating notice of motion dated the 28th of November 2022, the plaintiffs instituted action in the Supreme Court entitled SC 6/2022 to invoke the original jurisdiction of the Supreme Court pursuant to section 124 and 127 of the Constitution, Act number 6 of 1991, being for the following beliefs. A. The declaration that on a proper and interpretation of section 38A of the Constitutional Amendment Act number 15 of 2001, the controlling provisions stipulated in subsection 1 thereof, namely, all constituencies have not been established, are conditions precedent to warrant or justify the holding of a general election of the ordinary members of Parliament by the district block system herein after referred as the proportional representation system. B. A declaration that the directive by the President to the Electoral Commission of Sierra Leone ECSL to hold any public elections for ordinary members of Parliament by the proportional representation system where there are extant and subsisting constituencies is ultra vires the Constitution 1991 as amended. C. A declaration that the current Parliament was itself elected on a constituency basis as provided for in sections 38, 1, 2, and 3, and that these constituencies are still extant and subsisting. D. A further declaration that revision of constituencies as provided for in section 4, subsection 4 of section 38 does not necessarily result in the establishment of constituencies stipulated in section 38, 1, 2, and 3, but that rather the section provides for a period when existing constituencies should be reviewed, which revision may or may not necessarily result in a limitation of the respective boundaries of existing constituencies. E. A declaration that rely on section 38A of the 2001 Act as stated by the second defendant in their press statement would preclude independent candidates from contesting for Parliament as contemplated in section 77M of the Constitution of Sierra Leone, Act number 6 of 1991. F. A declaration that the entirety of section 38A of the Constitutional Amendment of 2001 does not provide nor contemplate local councils elections. The work basis on which local authorities were last elected is the subsisting and lawful basis on which any public elections involving local authorities can be held and not the proportional representation system. G. An order restraining the second defendant, its agents, servants, privys, or howsoever from taking any steps aimed at conducting the June 2023 multi-tier public elections on a proportional representation basis. H. An order directing the second defendant to hold the June 2023 election for ordinary members of Parliament on a constituency basis as presently established. A declaration that section 2 of the statutory instrument number 83 dated 16 November 2022 making provision for both proportional representation for members of Parliament and local council elections is altered by section 33 and 38 of the Constitution 1991. The application was supported by the affidavits of Honorable Abdul Kago, Member of Parliament representing constituency 077 in the Podloko district in the northwestern region of the Republic of Sierra Leone, and Councillor Hakiratu Maxwell Cocker, elected councillor for Ward 414 in constituency 118 in Freetown in the Western District. The first and second plaintiffs respectively, both sworn to on the 28th November 2022. On the affidavit of the first plaintiff, Honorable Abdul Kago, was attached two exhibits, namely Exhibit AK1, which is a true copy of Clause 57 of the Public Elections Bill 2022, and Exhibit AK2, which is a letter dated 15th November 2022 from Joseph Fitzgerald Kamara Esquire of JFK and Partners, solicitors for the plaintiff sharing to the Secretary to the President, requesting for the Secretary to the President to furnish them with a copy of the Presidential Directive issued to the Chairman of the Electoral Commission to conduct the June 2023 elections on the basis of the district block representation system. On the affidavit of the second plaintiff was attached one exhibit, to which exhibit HMC1, which a copy of the press statement dated 21st October 2022 from the second defendant hearing. Accompanying this originating motion, notice of motion and affidavit in support of motion, was the plaintiff's statement of case also filed on the same date, the 28th of November 2022. The defendant had 10 days hereafter service on them of the plaintiff's papers without leave to file a statement of the defendant's case. Service of the plaintiff's papers was effected on the 30th of November 2022 and on the 8th of December 2022, both defendants obliged this honorable court with statements of the defendant's case. Taking cognizance of Rule 97.1 of the Supreme Court Rules Public Notice Number 1 of 1982, which states that, quote, this court may, after considering the statement of the plaintiff's case and of the defendant's case and any argument of law, decide to determine the action and give judgment in court on a fixed date without argument. I have taken liberty to produce herein, despite their length, a verbatim production of the plaintiff's and defendant's case. Statement of the plaintiff's case pursuant to Rule 92 of the Supreme Court Rules. Facts and particulars of the plaintiff's case. The first plaintiff was elected as an MP in 2019 to represent constituency 77 in the Putloko district in the northwestern region of the Republic of Sierra Leone. The second plaintiff was elected as councillor in the Freetown City Council in 2018 for Ward 414 in constituency 118 in Freetown in the western area of the Republic of Sierra Leone. Both plaintiffs were successful candidates for the All People's Congress Party in the aforesaid elections. Since their election, the respective constituency and ward of both plaintiffs are still extant and subsisting, and they have not been delimited by division nor disestablished by law or otherwise. In 2022, a bill entitled the Public Elections Bill was introduced in Parliament. Clause 57 of the said bill provided as follows, quote, a general election of members of Parliament other than paramount chief members of Parliament shall be by A, one-member constituency system under subsection 2 of section 38 of the Constitution, or B, the district block representation system in accordance with section 38A of the Constitution, as set out in the 12th schedule, unquote. During the first and second readings of the bill, it was evident that there was strong and vocal opposition to the bill insofar as it purported to introduce the district block system of voting for the ordinary members of Parliament. The Speaker of Parliament, perhaps sensing the mood of Parliament, later unilaterally withdrew the said clause 57 from further consideration by Parliament. The Speaker then pronounced from the chair that proportional representation system of election was already part of the laws of this country in light of the amendment introduced by section 38A of the Constitutional Amendment Act number 15 of 2001. Then, on the 21st day of October 2022, the Electoral Commission for Sierra Leone issued a press statement in which it stated that on the directive of the President of Sierra Leone, it would use the district block voting system contained in the amendment to the Constitution introducing section 38A thereof. Submissions. In the forefront of and central to the plaintiff's case is that, given the provisions of section 38A, amending the then section 38 of the Constitution 1991, it will be ultra-vires and unlawful to hold the June 2023 multi-tier public election for the country on proportional representation basis, as stated in the Electoral Commission of Sierra Leone ECSL, press statement dated 21st October 2022, for the plain and simple reason that the condition precedent to bring Section 38A into operation, namely, quote, where there are no constituencies are not present, as there are extant and subsisting constituencies provided for in Section 38(1) of the Constitution 1991 and local council wards as provided for in the Local Government Act 2004. Therefore, it is submitted for the plaintiffs that to conduct the 2023 elections on the basis of the proportional representation system would offend the controlling provisions stipulated in Section 38A of the Constitution, to wit, where under any law for the time being in force, a date for a general election of members of parliament has been appointed, but constituencies have not been established in accordance with subsection 3 of Section 38. For the purposes of such election, the President may, after consultation with the Electoral Commission, direct that such election shall be conducted on the basis of the existing district in a manner to be known as the district block representation system instead of constituencies. Unquote. It is further submitted that the trigger, if you will, to bring proportional representation system into play for the purpose of elections in the country is, quote, where constituencies do not exist, unquote. Therefore, in the face of existing constituencies and wards, the forthcoming elections for parliament and ward cannot lawfully and properly be held on the basis of proportional representation. The predicate where in Section 38 is all important in the context of the meaning and effect of the section. The word itself intends to be a technical term in legislative drafting. It normally and best conveys the equivalent of general circumstances or a description of association. See Legislative Drafting Volume 1 by V. Clark, 1993, imprint 1998, Cavendish Publishing Limited, page 40. The plaintiffs respectfully urge this honorable court to take judicial notice of the fact that the present parliament comprises members who were elected during the last general elections in 2018 to represent their respective constituencies, and the same applies for the current members of the local authority. These respective constituencies and wards are in being, vibrant, and subsisting. This, it is respectfully submitted, is the peak and substance of the plaintiff's case. There are present subsisting constituencies and wards in the country for electoral purposes. This should, in or by itself, preclude the cost of proportional representation system of elections as provided in Section 38A of the Constitution. It is further submitted that proportional representation as contemplated and provided for in Section 38A of the Constitutional Amendment of Sierra Leone 2001 is itself a product of its time. It is a fallback position when there are no constituencies or wards for the purposes of elections in the country. This was the rationale and the prevailing circumstances that warranted and justified the amendment introduced to Section 38 of the Constitution 1991 and 2001 as now contained in Section 38A of the Constitution. The country had then just come through a brutal and destabilizing rebel war foisted on the country, which resulted, apart from the loss of human lives and destruction of property, in the destabilization of communities nationwide. An immediate effect of such a situation was the absence of settled community and constituencies. Hence the justification for the introduction of a proportional representation system. This was in a bid to restore the country to democratic civilian rule. It then was seen as a contingency provision and not intended to be a regular format of public elections or general elections for president. This is borne out by the operative words of the amendment in section 38A, but constituencies, quote, but constituencies have not been established, unquote. The amendment introduced by section 38A clearly speaks to a situation where constituencies have not been established in the country. It is further the case for the plaintiffs that these conditions do not now prevail in the country, and therefore in course cannot lawfully and properly be hard to such a system in the face of existing constituencies and wards. More, it is the case for the plaintiffs that a review and possible delimitation of constituency boundaries are provided for in section 38(4) of the Constitution of 1991 is not a viable or tenable excuse or warrant that in the absence of such review and delimitation, a course can be had to the proportional representation system as contained in section 38A of the Constitution. This is so for the simple reason that a review of boundaries of constituencies may or may not result in their delimitation. Section 38A of the Constitution only stipulates the time frame within which such a review may be done. It is further submitted for the plaintiffs that failure to embark on or complete such a review of boundaries exercise does not ipso facto result in the abolition or elimination of such constituency, so as to warrant the bringing into play of proportional representation system for electing the members of parliament. Therefore, in the present circumstances, it is submitted for the plaintiff that there is no warrant or justification for the use of proportional representation for the forthcoming elections. It is further submitted for the plaintiff that the use of proportional representation for public elections would negate the possibility of having independent candidates for such election, as is contemplated in section 77M of the Constitution, which relates to the loss of an elected independent seat on cross-carpeting to a political party. Moreover, it is the case for the plaintiffs that the proportional representation system gives primacy to a political parties list submitted to the Electoral Commission to the exclusion of the constitutional entitlement of every Sierra Leonean, subject to the requirement listed in section 75 of the Constitution 1991 to be entitled to be eligible as a candidate for parliament. The proportional representation system was intended for the conditions specified in the amending section 38A of the Constitution, and it was not intended to deprive Sierra Leonean citizens of the right to stand for and be elected as members of parliament by a mere signing, as is now contained in the second defendant's press statement. It is further submitted for the plaintiffs that since exceptional circumstances in 1996 and 2002, when the course was had for public elections to the proportional representation system, subsequent elections up to the present for parliament and local councils have since been on constituency and ward basis. The exceptional circumstances were, in 1996, the destabilized state of the country had, on the heels of military interregnum and the civil war, desire to return the country to an elected civilian rule after a combination of civil war and military interregnum between 92 and the year 2002 marked the official end of the civil war and the subsequent restoration of parliamentary constituencies. Therefore, it is submitted for the plaintiffs that the use of the proportional representation for parliamentary elections and local councils elections was done in those exceptional circumstances which do not now prevail. Accordingly, it will not be conducive to democratic civilian government in circumstances of a multi-party system to hold public elections now on a proportional representation system, which would be a throw to an earlier unsettled state of affairs in the country. the plaintiffs have invoked Section 1241 of the Constitution 1991, which provides as follows. The Supreme Court, quote, the Supreme Court shall, save as otherwise provided in Section 122 of this Constitution, have original jurisdiction to the exclusion of all other courts. A, in all matters relating to the enforcement or interpretation, emphasis added of any provision of this Constitution. And B, where any question arises whether enactment was made in excess of the power conferred on the Parliament or any other authority or person by law or under this Constitution, unquote. That is to say, respectfully, this Honorable Court is being asked to interpret, apply, and enforce by way of granting the several reliefs prayed for by the plaintiff in this matter as contained in the notice of motion. In this exercise, it is respectfully submitted that the task of this court is simple if regard is had to the basic principles and well-established canons of interpretation of statute. It is submitted respectfully that the first of these is that if there is nothing to modify or alter the language of the statute, it must be construed in the ordinary and natural meaning of the words and sentences used. This, it is urged respectfully, is the literal view of interpretation, which cuts down the ages since the 19th century have employed. See the judgments of Jessel, M.R. in Attorney General and Mutual Tontine in Westminster Chambers Association Limited, and Lord Fitzgerald in Bradcliffe against Clark. Again, it is respectfully submitted that the objective of all interpretation is to discover the intention of the lawmakers, which is deducible from the language, and once the meaning is clear, the court should give effect to it. The courts are not to repeat, and the courts are not to defeat the plain meaning of an enactment by an introduction of their own words into the enactment. Given the constitutional scheme of Section 38 of the 1991 Constitution, which stipulates that Sierra Leone shall be divided into such constituencies for the purpose of electing the ordinary members of Parliament, unquote, it is submitted that ordinarily such election should be on a constituency basis. We say so because Section 38A amending the Constitution envisages an extraordinary situation. No constituencies have been established for one reason or the other. This, on the evidence, is categorically not the case in this instance. See the affidavit of the first plaintiff, paragraphs 1 and 3. It is respectfully submitted that the salient words used by the legislature in Section 38A, amending the Constitution 1991 as follows, quote, where under any law, for the time being in force, a date for a general election of members of Parliament has been appointed, but constituencies have not been established in accordance with Section 3 of Section 38. For the purposes of such election, the President may, after consultation with the Electoral Commission, direct that such election shall be conducted on the basis of the existing districts in a manner to be known as the district block representation system instead of constituencies, unquote. In plain terms, it is respectfully submitted that the intention of the legislature in enacting this section was simple, namely, where a date for that election has been appointed, but no constituencies exist in accordance with Section 8.3 of the Constitution, then and only then we submit the President may, after consultation with the Electoral Commission, direct that such an election shall be conducted on proportional representation basis. What is the evidence in this case of the plan? Clearly, from the press statement by the Electoral Commission itself, a date for the general election has been appointed, namely the 24th of June 2023. Also clear as a pipeline is that there are existing constituencies and was established pursuant to Section 38 of the Constitution 1991, and the wards under the local Government Act 204, Boundary Delimitation Regulation 208, and Constitutional Instrument number 2 of 2008, respectively. It is accordingly submitted respectfully that the press statement of the second defendant stating that the 2028 elections will be on a proportional representation basis finds no validity or affirmation in the clear and plain words of Section 38A of the Constitution. It is further respectfully submitted that Section 38A of the Constitution does not give the President carte blanche power to direct that elections be held on a proportional representation basis regardless of the controlling words of this section, namely what constituencies have not been established, unquote. It is therefore respectfully submitted that to find or hold otherwise is to fly in the face of the clear words and plain meaning of Section 38A1 of the Constitution and the weight of evidence in this case. The unconstitutionality of statutory instrument number 83 and 83 of 16 November 2022. Paradoxically, it is to be noted that these statutory instruments, given the same number, purport to address both parliamentary and local council elections, respectively. The claimed warrant or authority for this instrument is Section 33 of the 1991 Constitution. It is submitted respectfully for the plaintiffs that this section confers no warrant or authority as claimed in the said statutory instrument to change the format and mode of a local government elections. Section 33 of the Constitution undoubtedly confers on the Electoral Commission the power to make. Section 33 of the Constitution undoubtedly confers on the Electoral Commission the power to make regulations, but such regulations cannot change the form of elections for parliaments and local councils as purportedly claimed in the statutory instruments. It is again respectfully submitted for the plaintiffs that to change the form of election of members of parliament and local authorities is a deliberate matter for primary legislation. The form for electing a member of local authorities is specified in the Local Government Act 2004, more particularly in subsection 4 of section 4. The power given to the Electoral Commission under of the Constitution and section 171 of the Public Elections Act 2002 is to conduct and supervise elections and not to determine the form or mode of elections. To change the format or mode of elections it is submitted a matter for primary legislation. Reserved for the legislation. Prescribing the form of election or changing the electoral system. Section 68 of the Public Elections Act 2022 enumerates what constitutes conduct of election by the Electoral Commission. Nowhere in the entirety of Section 68 is it suggested that the Electoral Commission can change the form or mode of electoral system. The powers exercised under the statutory instrument by the Electoral Commission are in excess of the powers conferred under Section 33 of the Constitution 91 and 171 of the Public Elections Act number 17 of 2022. Conclusion. In conclusion, it is urged respectfully that on the law and the evidence, in this case, it will be ultra-vires and unlawful to hold the June 2023 elections on the proportional representation basis for the following reasons. First, such elections on a proportional representation basis would offend the clear provisions of Section 38A of the Constitutional Amendment 2001. This section simply provides that the President, in consultation with the Electoral Commission, be direct latter to conduct such election on a proportional representation basis, where constituencies have not been established. Second, on the evidence there are currently established and existing constituencies in the current parliament of this country. Thirdly, the contingent circumstances envisaged in section 38A of the Constitution as amended are not present in the proportional representation system for the 2023 elections. Fourthly, it will be wrong and impermissible in a democratic state to invest the president with the sole power to order and direct a proportional representation system for public elections without the concurrence of parliament and in the face of existing constituencies. Fifthly, it is for all these elections that they beseech this honorable court to grant the reliefs they seek in their motion. Sixth, the proposal to hold the June 2023 election on a proportional representation basis would flout and ignore the constitutional scheme stipulated in section 38(1) of the Constitution. This provides that Sierra Leone shall be divided into such constituencies for the purpose of electing the members of Parliament on oath, which provision was amended in 2001 by the Constitution of Sierra Leone Amendment Act number 15, 2021 by inserting paragraph 8 to section 38 as follows, quote, where under any law for the time being enforced, a date for a general election of members of Parliament has been appointed, but constituencies have not been established under section 3 of section 38 for the purposes of such election, the President may, after consultation with the Electoral Commission, direct that such election shall be conducted on the basis of the existing district in a manner to be known as the district block representation system instead of constituencies. Unquote. The plain and irrefutable evidence before this court, as per the affidavits of the plaintiffs, is that there are present and existing constituencies in the country for parliamentary purposes. Seventhly, the multi-tier election and the proportional representation as stated in the statement of the second defendant finds no jurisdiction in either the Constitution of the country's laws regarding local authorities elections. Plaintiff counsel's argument. In his argument before this court, Leone counsel for the plaintiffs, Dr. Abdullahi Conte, submitted that this case was not about the merits or the merits of proportional representation system. At the heart of this case, he argued, was the crucial issue of whether the 2023 multi-tier elections involving parliamentary and local councils elections should be held through a proportional representation system, which he concluded strikes at the heart of the rule of law, in that whether we can truly say as a country we are governed by the rule of law and the Constitution of Sierra Leone. He further submitted that the proportional representation was not an alternative system of election in a democratic country governed by the rule of law. He argued that it was section 38A(1) of the Constitutional Amendment Act number 15 of 2001 that introduced such system, but it must be read in conjunction with section 38(1) of the Constitution of Sierra Leone Act number 6 of 1990, which had imposed a constituency-based election, in which case it must be concluded that section 38A is not freestanding or alternate. Thus, he argued, the powers vested in section 38A of the Constitutional Amendment must be exercised within the parameters of the Constitution Act number 6 of 1991, which provided that elections in constituencies based as in section 38(1) thereof. He further submitted that apart from it not being freestanding, this case was about the limit of that power vested on the President and that of the Electoral Commission, and when and how that power to run elections by proportional representation system could be lawfully exercised. He submitted that it was against this background that he was now submitting that the directive given by His Excellency the President to the Electoral Commission for it to run the 2023 elections following the alleged consultation of the Electoral Commission to be altered by the Constitution. We are not questioning the directive per se, except that it was altered by the Constitution because there were already existing constituencies. He was quick to note that the plaintiffs were further questioning whether the Electoral Commission was right in advising the President to make such a directive when the conditions precedent in their estimation has strictly not been met or followed. In this context, the defendant's reliance on Section 53, Sub 3 and 171.14 of the Constitution was plainly out of context and misconceived. The court will no doubt and clearly be performing its role if it declared that the President was wrong in giving this directive when the conditions precedent for holding general elections with proportional representation system have clearly, in this instance case, not been met. He likes the case of Vagina of the application of Miller, appellant, versus the Prime Minister, respondent, Cherry and others, respondents, versus Advocate General of Scotland, appellant, Scotland. Where the Supreme Court in UK had to consider whether the Prime Minister's advice to the monarch was justifiable or not. He observed that this court would do well if it adopted the statement of Lady Hill when in paragraph 4 said that, quote, if the chief of the court is justifiable, deciding it will not offend against separation of powers. The court will be performing its proper function under our Constitution, unquote. Turning to the issue of whether the conditions for the running of an election via district block proportional representation system were met, Learning Council for the plaintiffs urged the court to consider the two conditions precedent, which must be met as follows. Firstly, one, the date for the general election must have been fixed. Secondly, and most importantly, whether constituencies have not been established. He submitted that the determination of these two crucial issues must be based on evidence and an analysis of the law, taking their role as the conditions which must be satisfied. He submitted whether the date had been fixed was in the affirmative, and the yes answer. Regarding the answer to the second question as to whether constituencies have not been established, the response he noted was that constituencies had long existed and were subsisting as evinced by the fact that members of Parliament were currently sitting in Parliament and that the first linked hearing was the Member of Parliament representing 132 constituencies, to which constituency 77 in the Podolo district in the northwest region of the country. He argued that on the contrary, there was no evidence in the portal of the fact that constituencies were existing to show that there were no constituencies existing as required by the preconditions for the use of proportional system of representation. Against the foregoing, he argued any decision to hold the election through proportional representation outside section 31 will be strictly unlawful. Learning Council for the plaintiff, Dr. Abdullahi Conte, concluded on this point by submitting that it would be the most unusual and exceptional circumstance that would warrant the holding of a multi-party election through a peer system of elections and not when there is democracy. He argued further that it was incumbent on the Electoral Commission to provide reasons why it was necessary to change the form of election from a constituency-based first-past-the-post system to a proportional representation system. As far as he was concerned, up to this time, there has been no explanation given by the defendant Electoral Commission why it had to change the form of elections. He submitted that the lack of explanation must be confusing to the electorate and the general public. In the alternative, however, it appeared he argued also that if there was an excuse of inability or impracticability to complete the exercise of the limiting boundaries which the Electoral Commission of Sierra Leone had started, it was a very lame excuse and that was only accepted if the so-called excuse was made through an affidavit and subjected to scrutiny through cross-examination in the court. He submitted that the Electoral Commission has sought to extinguish constituencies unilaterally when such constituencies still subsist. Leone Council then turned to the unconstitutionality of what he called statutory regulations, numbers 83, but indeed was statutory instrument numbers 13 and 14 of 16th November 2002, to which the Electoral Commission used to put the proportional representation system into effect or operation. Leone Council submitted that the second respondent seems to take succor in statutory instrument number 83 and 83 for the setting up of the PR system, but such a power cannot change the form or format of elections, noting and submitting that to change the format or form was a deliberate matter for the legislature in the primary legislation and not secondary instrument. Accordingly, to change the format and mode of election by statutory regulation, which is secondary, will be plainly ultra-virus. They urge that the word conduct does not include setting the format. He refers to Section 68 of the Public Election Act number 17 of 2022 to illustrate what constitutes regulation for conduct of elections. He concluded by stating that because of the aforementioned, what the Electoral Commission, the second respondent, second defendant, did by the said regulations to statutory instrument number 15, numbers 13 and 14 of 2022 was in excess of their powers and accordingly ultra-virus. It therefore urged His Lordship to grant the reliefs paid for. The first defendant, statement of first defendant's case, pursuant to 92.1 of the Supreme Court Rules, 1982. Facts and particulars of the case. The first defendant, who is the Attorney General Minister of Justice, is the principal legal advisor to the government of Sierra Leone, including its ministries, departments, and agencies. The second defendant is the Electoral Commission for Sierra Leone, ECSL, responsible for the conduct and supervision of the registration of voters for and of all public elections and referenda, and for that purpose shall have powers to make regulations by statutory instruments for the registration of voters, the conduct of presidential, parliamentary, and local government elections and referenda, and all the matters connected therewith, including regulations for voting by proxy. The second defendant, in compliance with its constitutional mandate, the Constitution of Sierra Leone Act number 6 of 1991, hereinafter referred as the Constitution, on the 21st day of October 2022, issued a press statement in which it stated that on the directive of the President of Sierra Leone, 2023 multi-tier elections will be conducted using the proportional representation system as provided for in Section 38A(1) of the Constitutional Amendment Act of 2001, Act number 15 of 2001, and that the boundaries limitation exercise, which had commenced, is halted with immediate effect. That the plaintiff's hearing being dissatisfied with the press statement of the second defendant, on the 28th day of November 2022, filed an originating notice of motion to the Supreme Court of Sierra Leone pursuant to Section 1241 of the Constitution. The main plan of the plaintiff's case is that to conduct the 2023 elections on a district block representation system would offend the controlling provisions in Section 38A(1) of the Constitution as the reasons for the Constitutional Amendment Act 201 which amended the Constitution introducing Section 38A, are presently not subsisting. Sections 38 and 38A of the Constitution provides for constituencies and the election of members and prescribe which process and under which conditions they should be carried out. That the President, in consultation with the ECSL, has directed that such elections shall be conducted pursuant to Section 38A in a manner to be known as the least block system. Additionally, the ECSL has the powers to cause a review of constituency boundaries at intervals of not less than 5 years and not more than 7 years. Section 38A4 states, quote, the Electoral Commission shall review the division of Sierra Leone into constituencies at intervals of not less than 5 and not more than 7 years, and may alter the constituencies in accordance with the provisions of this section to such extent as it may consider desirable in the light of that review. Unquote. Further, Section 38B and the proviso thereof deals with how constituency boundaries should be determined. The population quota, as referred to in the proviso, is defined in the Constitution to mean the number obtained by dividing the number of inhabitants of Sierra Leone by the number of constituencies into which Sierra Leone is divided under Section 38 of the Constitution. Therefore, to delimit boundaries, the first thing to do is to divide the population of Sierra Leone to determine the population quota, and thereafter the population quota will now determine constituency delimitation. See subsection 6 of Section 38 of the Constitution. To ascertain the population quota, reference should be made to the latest population census. See subsection 7 of Section 38 of the Constitution. Therefore, the unmentioned facts since the 1991 Constitution was enacted for which we urge. Therefore, the unmentioned facts since the 1991 Constitution for which was enacted, for which we urge the court to take judicial notice of, ought to be borne in mind as we make our submission. A population and housing census was conducted in December 2004. B. Thereafter, constituencies were reviewed, altered, and delimited in 2007 by the National Electoral Commission, thus establishing 112 constituencies for the purpose of electing members of parliament for the 2027 general elections. C. Another population and housing census was conducted in December 2015. D. Constituencies were again reviewed, altered, and delimitation done on the 17th of February 2017 based on the 2015 population and housing census. Wherefore, 132 constituencies were established for the purpose of the 2018 election for members of parliament. In July 2021, a midterm population and housing census was conducted. F. The results were announced on the 15th of September 2022, showing substantial growth in the population figures at regional, district, and chiefdom levels. G. The date for elections for members of parliament was announced by the President to be on the 24th of June 2023. H. Constituencies have not been reviewed, altered, and delimited to be so established for the purpose of the June 24th June 2023 general elections. The Electoral Commission cannot, after the 23rd of December 2022, update and revise the voters' register due to the provisions of Section 18 of the Public Elections Act 2022, Act number 17 of 2022, and Article 2 of the ECOWAS Protocol for Democracy and Good Governance, ASP 1-1201, supplementing to the protocol relating to the mechanism for conflict prevention management, resolution, peacekeeping, and security, December 2001. Nevertheless, it is the contention of the plaintiffs that the conduct of June 2023 multi-tier public elections based on the district block representation system pursuant to section 38(1) of the 1991 Constitution as amended in the absence of the condition listed, namely, quote, where constituencies do not exist, unquote, will be ultra-vires and unlawful. The plaintiffs argue that the trigger for the district block representation system is where constituencies do not exist, unquote, quote unquote. They are asserting that there are extant and subsisting constituencies and local council boards pursuant to section 38(1) of the Constitution and the Local Government Act of 2004, Act number 15 of 2004, and urge the court to so hold. Submissions. It is a submission that the plaintiff's assertion, based on their interpretation of the provisions of sections 38 and 38A of the 1991 Constitution, cannot hold in law. The provisions of section 38 and 38A are being deliberately misconstrued by the plaintiffs. We hereby submit a legal argument and interpretation of section 38 and 38A of the 1991 Constitution as thus. In the instant case, the provisions in section 38A were triggered after there had been a population and housing census and the results announced, with a significant alteration in the population group of the Electoral Commission of Sierra Leone not reveal the election of members of parliament slated for June 2023. The midterm census was conducted in July of 2021 and the final results announced on the 15th of September 2022. Prior to the publications of the final census result, the President announced the date of the general elections, which was June 2023. That the Electoral Commission, after a consultative meeting with the President on the 19th of October 2022, updating him on the progress relating to the boundary delimitation exercise being undertaken and the impracticability of complying with section 38(3) of the Constitution, necessitated the directive of the President. This directive so given was done by an authority conferred on the President by the Constitution under section 38A(1) of the Constitution, now amended. The wordings of section 38A(1) inter alia clearly states, quote, where under any law for the time being enforced, a date election of members of parliament has been appointed, but constituencies have not been established in accordance with subsection 3 of section 38. For the purposes of such election, the President may, after consultation with the Electoral Commission, direct that such election be conducted on the basis of the existing district in a manner to be known as the district block representation system instead of constituencies. Quote. Section 38(3) states that, quote, the boundaries of each constituency shall be such that the number of inhabitants thereof is as nearly equal to the population quota as is reasonably practicable, unquote. Section 38(7) states, quote, for the purpose of this section, the number of inhabitants of Sierra Leone shall be ascertained by reference to the latest census of the population of Sierra Leone held in pursuant of an act of parliament, or if no census had been so held, by reference to any available information, which in the opinion of the Electoral Commission best indicates the number of those inhabitants, unquote. It is a submission that the latest census in Sierra Leone is the midterm census conducted in 2021, for which final result was announced on the 15th of September 2022. Based on the said census results, there was significant population growth from 2015 to 2021 in the regions, districts, and chiefdoms by 6.4%, which necessitated the review 7 of the Constitution. Exercise based on the census, on the latest census result, and the date of the election of members of Parliament has been appointed or announced by the President for the 24th June 2023, and the President having had consultation with the Electoral Commission on the impracticability of reviewing, altering, and delimiting constituencies. Therefore, prudent for us to listen, and we do submit that legally constituencies have not been established for the forthcoming election of members of Parliament pursuant to Section 38(3) of the Constitution. Emphasis, right. It is fair and just and to perform this constitutional by the district block representation system be used instead of the constituencies. In effect, the application filed by the plaintiff and the second relief prayed for is contravening the provisions of Section 53 sub 3 and 171 sub 14 of the Constitution. These provisions state thus. 53(3) quote, whereby this Constitution or under any other law, the President is required to act in accordance with the advice of any person or authority. The question whether he has in any case received or acted with such advice shall be required by any court, in any court, unquote. 171(14) provides as follows: where under any provision of this Constitution, any person or authority is authorized or required to exercise any function after consultation with some other person or authority, the person or authority shall not be required to act in accordance with the advice of that other person or authority. And the question whether such consultation was made shall not be inquired into in any court, unquote. Now this court must have jurisdiction to grant the orders prayed for on the subject matter before it, and that without jurisdiction the whole proceedings become a nullity with no legal effect. That by virtue of the restrictions placed in the above provisions in paragraph 6 thereof, this court has been deprived and lacks the necessary jurisdiction to adjudicate on the second relief prayed for, thus subjecting the President's directive to scrutiny by the court, which is legally wrong. Where the boundaries have not been reviewed to determine the actual inhabitants with respect to the latest census, that is the mean-term census, an election on constituency basis, system will be in complete violation of the Constitution, particularly when the date of election has been. The argument by the plaintiffs that there is no condition precedent to invoke Section 38(a) is flawed, baseless, and frivolous, and cannot be legally countenanced by this court. The impracticability to comply with Section 38 and 7 triggers the invocation of Section 38(a). It is the defendant's submission that Section 38(a) was never introduced into our laws for a specific purpose, as averred by the plaintiffs in paragraph 17, 25, 26, and 27 of their statement of case. Had it been so, it would have been repealed and replaced immediately after the 2002 elections. But the doctors of that provision envisioned a situation where there would be a census, but constituencies have not been reviewed, altered, limited, and established. Hence, the essence of Section 38(a). If the government wanted to limit the applicability of the provisions of Section 38(a) to a one-off situation, they would have said so clearly. Furthermore, if it were to be believed that the 2001 amendment to the Constitution was as a result of the law, that would have been possible, because it would have gone against the principle of posterity, which is one of the objectives of which constitutions, as in this case the Constitution of Sierra Leone. See the preamble to the Constitution of the United States. It is further submitted that contrary to the misplaced visits covered in paragraphs 17, 25, 26, and 27 of the plaintiff's case for the 2001 Constitutional Amendment, the actual reason for the amendment to Section 38 of the Constitution was necessitated by circumstances, quote, circumstance emphasis in which the Electoral Commission finds itself in a situation where a population census has to be conducted, a date for the general election announced, but the Commission is reasonably unable to review all the purpose of such election. Following the population and housing census in December 2004, the Electoral Commission conducted a review of constituencies in 2006, where all the constituencies alternated and 112 constituencies 20. The plaintiffs argue that the elections for ward councillors cannot be lawfully and properly held on the basis of proportional representation. We adopt our arguments in paragraph 1 to 10 with the necessary modifications to wards. Wards boundaries of 394 wards in 2008 after the 2004 census. We state that by the provisions of Section 33 of the Constitution, the Electoral Commission is empowered to make regulations for local councils elections and constitutional instrument number 82 of 208 vests the authority to review wards based on the national population quota, which is ascertained by reference to the latest census. In this case, the latest census is the midterm census. It is therefore a submission that the constituencies and wards ought to be reviewed for the delimitation and establishment of wards for the purpose of the June 2023 elections, local council elections, as a result of the midterm census. The plaintiff in paragraph 3 and 24 of the case states that the proportional representation system will negate the possibility of having independent candidate for such election. This assertion is speculative and not legal. Section 75 of the Constitution sets out clearly the requirement for a person to be elected as a member of Parliament irrespective of the form of electoral system so used. Once those requirements are fulfilled, nothing stops a person, be it independent or not, from being given the opportunity to contest. To contest this point, Section 58(1) and 58(c) states, a candidate shall be nominated in writing by 3 voters of the electoral area for which he intends to contest. And 58(c) states the political party of a candidate as applicant. This simply means not all candidates will be nominated by the political parties. The plaintiffs further failed to establish their locus with respect to their case for independent candidates. The plaintiffs are both members of the All People's Congress Party and not independent candidates. They have not established their standing as to this argument, and therefore we submit that their argument in respect of it must not be entertained. That the applicants are further seeking this court to declare statutory instrument number 83 and 83 dated 16 November 2022 based on the argument that the Electoral Commission has acted in excess of the powers conferred under Section 33 of the Constitution and Section 171 of the Public Elections Act. It is a submission that the statutory instruments were laid in the House of Parliament on the 23rd of November 2022 by the Office of the Attorney General of the Constitutional and Statutory Instrument Act 1999. It states that any instrument so laid before Parliament shall have the force of law after 21 days unless before defeated vote majority. The said instruments are yet to have the force of law when the plaintiffs were yet to have the force of law when the plaintiffs filed the application to have it set aside. The application filed He stated the 28th November 2020, that is 5 days after it was laid before Parliament, they have not met any of the requirements for the document to be matured. And yet the applicant is seeking this court to act in vain by declaring it ultra vires. Can this court declare an instrument which is yet to have the force of law ultra vires? Conclusion. By reason of the submissions here, we pray that the orders prayed for are stated in 1 to 9 that the plaintiffs in the originating notice of motion be dismissed with cost to the first defendant. First defendant's counsel. Argument. Counsel's argument. Both defendants opposed the granting of the relief suite for. In the case of the first defendant, they relied entirely on the submissions made in the statement of the first defendant's case filed on the 8th of December 2022. In particular, with regard to the unconstitutionality of statutory instrument numbers 13 and 14 of 16 November 2020, they argue that at the time of filing this originating notice of motion that instrument was yet law, but as of now, the instrument has received a certificate of maturity and is now law, in which case it cannot be regarded as unconstitutional. Turning to the issue of whether the conditions precedent for the holding of elections to PR, which related to the first, second, third, fourth, fifth, and sixth relief paid, the first defendant's counsel, Solicitor General, argued that the plaintiffs were not reading Section 38A in full, and that a full reading of it would no doubt bring in focus that it was not, that constituencies do not exist, but that they have not been established in accordance with subsection 3 of section 8 for the purpose of such elections. Argued brought into focus census and its relevance in the limitation of boundaries for the constituencies. He submitted that a midterm census was concluded with results published in September 2022, which results definitely necessitated a review of the current existing constituencies. However, because of the ECOWAS Protocol and Section 18 of the Public Elections Act number 17 of 2002, it was impossible to conduct any exercise to delimit boundaries without offending the aforesaid provisions. He argued that the advice by the Electoral Commission and the directives given by the President were within the mandate of the law provided in Section 38A. On the issue of independent candidates, Mr. Kowa, the Solicitor General submitted that no independent candidate has brought a claim before this court, and for that issue to have been raised by a non-independent candidate was against the principle established in a normal case or local standard, as the so-called plaintiff lacked local standard. He argued further that assuming that the court was inclined to consider the grateful that the statutory instrument numbers 13 and 14 have made adequate provision for independent candidates in Regulation 10 thereof. Regarding the second relief grateful, Counsel for Plaintiff Mr. Osman Kanu submitted that with the declaration that the directives and the President told the Electoral Commission of Sierra Leone to hold any public elections for ordinary members of Parliament to violence where there are extant and subsisting constituencies. Relying on sections 53, sub 3 and 17114, he argued that the court could not inquire into how that directive was given. He noted the submissions of counsel for the plaintiff and the case relied upon, but noted that unlike England, which has an unwritten constitution, Sierra Leone was bound by a written constitution. He therefore asked that the defendant the declaration be reviewed. Regarding relief 7, 8, and 9, he noted that these were all consequential reliefs which would flow if this court were to grant orders 1, 2, 5, and 6. Lastly, he noted and submitted that the plaintiffs have not complied with Rule 89 sub 2 with regards to their file. Statement of the second defendant's case pursuant to Rule 92(1) of the Supreme Court Rules 1982. The second defendant filed a statement of case, the same which is constituted by 54 paragraphs. Paragraphs 1 to 30, 38, 39, and 40 are produced here in verbatim. The rest I will make reference to as and when necessary. Facts and particulars of the case. The second defendant is the Electoral Commission for Sierra Leone, ECSL, responsible for the conduct and supervision of the registration of voters for and all public elections, referenda, and for that purpose shall have powers to make regulations by statutory instrument for the registration of voters, the conduct of presidential, parliamentary, or local government elections and referenda, and other matters connected in addition to that, including regulations for voting by proxy. In order to carry out its constitutional mandate, the Constitution of Sierra Leone Act 6 of 1991, hereinafter referred to as the Constitution. The second 2022 as directed that the 2023 multi-tier elections will be conducted using the proportional representation system as provided for in Section 38A of the Constitutional Amendment Act of 2001, Act 115 of 2001, and other which are commenced will be recorded with immediate effect. Dissatisfied with the press statement of the second defendant, on the 28th of November 2022, the plaintiffs herein filed an originating notice of motion to the Supreme Court of Sierra Leone pursuant to Section 124 of the Constitution. The plaintiff's argument are centered on the 23 elections of the district block representation system would violate Section 38A of 1 of the Constitution. The issues and situations that should trigger neutralizing provisions of the Constitutional Amendment Act 1, which amended the Constitution by introducing Section 38A. Sections 38 and 38A of the Constitution provide for constituencies and elections of members of Parliament and do prescribe proportional representation. The second defendant submits that the President of Sierra Leone, in consultation with the ECSL, directed that the 2023 elections be conducted according to Section 38A in a manner to be known as district block representation system. Additionally, the second defendant has powers to cause a review of constituency boundaries at intervals of not less than 5 years and not more than 7 years. Section 38.4 states, quote, the Electoral Commission shall review the division of Sierra Leone into constituencies at intervals of not less than 5 and not more than 7 years, and may alter the constituencies following the provisions of this section to such an extent as it may consider desirable in the light of the review, unquote. The constitutional provision of 38.3 and the proviso thereof deal with how constituency boundary delimitation should be determined. The population quota referred to in the proviso is defined by the Constitution as the number obtained from dividing the number of inhabitants of Sierra Leone by the number of constituencies into which Sierra Leone is divided under Section 38 of the Constitution. Therefore, to delimit electoral boundaries, the first thing to do is to divide the population of Sierra Leone by the number of seats in Parliament to determine the population quota. Thereafter, the population quota will now determine constitution of Section 38 of the Constitution. To ascertain the population quota, reference should be made to the latest population census, or if no census have been held, by reference to any available information, which in the opinion of the second defendant best indicates the number of those inhabitants. See subsection 7 of Section 38 of the Constitution. For the second defendant states the following fact for the attention of the court. A population enhancement census was conducted in December 2004. B, an integral review, alteration, and delimitation of constituencies in 2006 by the National Electoral Commission, thus establishing 112 constituencies to elect members of Parliament for the 2007 elections. C. The second population and housing census was conducted in December 2015. D. Again, the population and housing census of 2015 repeated the same process where constituencies were again reviewed, altered, and the delimitation approved by the Parliament on the 17th February 2017. Based on the 2015 population and housing census, 122 constituencies were established for the 2018 elections for members of Parliament. In July 2021, midterm population and housing census were conducted with the results announced on the 15th of September 2022. This statistic shows that there was a significant change in the population, with substantial growth in the population figures at regional district and chief of June 2023. At this stage, constituencies are not yet reviewed, altered, and delimited based on the trend and practices shown above. That after every census, the outcome should lead to the delimiting of boundaries for the forthcoming elections of the 24th of June 2023. The second defendant is legally barred from updating and revising the voter registration by Section 18 of the Public Elections Act 2022, Act number 17 of 2022, and ECOWAS Protocol on Democracy and Good Governance, ASP 1-112-01, supplementary to the protocol relating to the mechanism for conflict prevention, management, resolution, peacekeeping, and security, December 2001. Therefore, the condition precedent presented itself for the second defendant to advise the President that it was impracticable to run a proper constituency-based election. The advice was because, firstly, wrongly placing people into constituencies, and secondly, a complete boundary delimitation. A central contention of the plaintiff is that the conduct of the 2021 of the 1991 Constitution, in the absence of the condition precedent, namely where conditions do not exist, quote unquote, will be ultraviolent and unlawful. The plaintiffs argue that the trigger of the district block representation system is, quote, where constituencies does not exist. Plaintiffs further assert that their extant and subsisting constituency and local council works according to Section 38(1) of the Constitution and the Local Government Act of 2004, Act of 2004, which remain for forthcoming elections. Submissions. The second defendant submits that it has acted according to the provisions of the National Constitution, electoral laws, and the law governing census in Sierra Leone. The second defendant further asserts that the plaintiffs are giving a narrow interpretation of Sections 38 and 38A of the 1991 Constitution. Sections 38 and 38A should be unrestricted to the post-war situation or any specific situation. The said sections apply to a litany of eventualities where constituency elections are either impracticable or impossible. We submit a legal argument and interpretation of Section 38 and 38A of the 1991 Constitution as thus. As the sole body responsible for conducting elections and with more profound knowledge of the intricacies of undertaking boundary delimitation, the 2022 midterm population and housing census heralded demographic shifts that altered the population of Sierra Leone from 53,000 to 57,000 population. This triggered the need for a review of the existing boundaries, delimitation of shifted current constituencies, and establishment of new constituencies for the upcoming 24th of June 2023 elections. The second defendant submits that one Statistics Sierra Leone, the only legal institution responsible for housing and population census in the country, has successfully conducted a census. Boundaries are bound to be delimited. Sufficient examples start with the events leading to the 17th of February 2017, when boundaries were delimited based on the 2015 census. There were 112 parliamentary seats in 2012. By 2017, while the House of Parliament was still in session, the ECSL, by the powers conferred on them by Section 38(3) of the 91, reviewed the boundaries of the constituencies. This led to a significant movement of people and the creation of 20 more constituencies to the existing constituencies. As a result of the fact that the President announced the election dates for the 24th of June 2023 to respect the Constitution's mandate of 5-year limit, it became practically impossible for the Electoral Commission to complete an unquestionable delimitation within the timeline fully. Therefore, in consultation with the President, at a meeting on the 19th of October 2022, in which the President was briefed on the progress and challenges of fully practicalizing mandates of Section 38(b), the President directed that the second defendant conduct the elections in June 20 on a proportional representation basis. Thus, the district block system for which this interpretation is sought. Section 38(3) states that, quote, the boundaries of each constituency shall be such that the number of inhabitants thereof is as nearly equal to the population quota as is reasonably practicable. The wording of Section 38(a), among other things, clearly states that, quote, but constituencies have not been established under subsection 3 of Section 38, unquote. The said subsection of Section 38 provides that the electoral boundaries of each constituency shall be such that the number of inhabitants thereof is as nearly equal to the population quota as is reasonably practicable. To determine this population quota, the 1991 Constitution directs in that Section 7 of subsection 38, quote, the number of inhabitants of Sierra Leone shall be ascertained by reference to the latest census of population held in pursuance of Act of Parliament. It is further submitted that on the 17th of February 2022, the boundaries delimited in 2017 reached the 5 years minimum threshold. The law allows the government through statistics to conduct a housing and population census to show the correct and accurate habitation of the people of Sierra Leone. This led to a mid-term census, and once statistics presented, the census to the second defendant, it was bound to review the boundaries of the existing constituencies to ensure elections are conducted from the accurate population density and as representative of the sparseness of the population. The only figures that will generally represent the present-day Sierra Leone population shall come from the latest census conducted by the legal authority. In this case, the census figures are the midterm outcome, and it will be erroneous and unfair to leave those recent statistics and use an old 2015 census outcome. The 1991 Constitution is very instructive when it provides in Section 38(7) that, quote, for the purposes of this section, the number of inhabitants of Sierra Leone shall be ascertained by reference to the latest census of the population of Sierra Leone held in pursuance of an Act of Parliament, or if no census has been held, by reference to any available information which, in the opinion of the Electoral Commission, best indicates the number of those inhabitants. It is clear from the figures of the midterm census that a significant population shift and growth in specific regions, districts, and chiefdoms have occurred, and which makes it imperative for ECSL to review the boundaries that constitute the constituencies as provided in Section 38, 3, 4, 6, and 7 of the Constitution. It is the second defendant's informed position that there was and is a need to review the existing boundaries due to the shift in population The 2017 electoral boundaries cannot be regarded as a data because they have to be established under the recent sectors and cannot inform the population distribution for the voting of the elections. The second defendant's legal role is to advise the president on what is doing, feasible and practical, considering all the circumstances at a given time, advising the president on a proportional representation system in the face of the impracticability of limiting the boundaries, but fair, just, and legal. Based on the impracticability of fully complying with Section 38(3), the second defendant, with the advantage of unique and specialized knowledge information, advised the president of the eventuality of Section 38A. The president so directed in exercising was triggered, and the president was bound to exercise his powers under Section 38A by giving the directives as deed to the ECSL. While the state will argue this, ECSL believes that the directives given by the president touching on using a district block representation system of the June 2023 elections were done in good faith, followed the dictates of the spirit, letter, and intent of the wordings of Section 38A of the 1991 Constitution. The wording of Section 38A, among other things, clearly states, quote, where under any law for the time enforced the date for a general election of members of parliament has been appointed, but constituencies have not been established in accordance with subsection B of Section 38 for such election, the president may, after consultation with the Electoral Commission, direct that such election shall be conducted based on the existing districts in a manner to be known as a district block representation instead of constituencies. Unquote. Considering that the Constitution provides that elections shall be held every 5 years, and a date has been announced to that effect, where the boundaries have not been so reviewed to determine the actual inhabitants with reference to the latest census, that is the midterm census, an election on the constituency-based system will be in complete violation of the Constitution, particularly so when the date for the election has been announced. Which underscores the spirit of democratization. The second defendant will argue that the constituencies and wards cease traces since statistics Leone legally conducted the country's population census under the power conferred on them by law. To counter the existing midterm census result, a new census had to be undertaken, or the extant midterm census be declared illegal by a competent body with the power to do so. It is the second defendant's position that in the absence of legitimate boundary delimitation by the second defendant, elections for both ordinary members of parliament and local council can only be conducted according to the provisions of Section 38A of the 1991 Constitution. The plaintiffs argue that there is no condition precedent to invoke Section 38A. As explained in paragraphs 5, 6, 7, 8, 9, and 10, the mere impracticability of the limiting boundaries in the face of a significant shift in the population density in the country is enough for a condition precedent to surface and summon Section 38A. The point is mute, misplaced, and flawed, and should be discounted by the court. The second defendant submit non-transition. It was not introduced into a law just for the war situation, as the plaintiffs in paragraph 17, 25, 26, and 27 of their statement of case have said. The draft new conditions will occur when constituency elections will be impracticable and a remedial provision was needed. If they wanted it to be transitional or transient, they would have said so. It is also the defendant's submission that in 2016, in the final report by the Constitutional Review Committee, made up of 80 members, including representatives of all political parties, They all agreed on pages 260 to 61 that the proportional representation system was a more democratic members of parliament. That there are over 80 stable democracies that practice different forms of proportional representation. Among these countries, we have Switzerland, where most of the United Nations offices are housed and which has enjoyed peace and stability since the First World War. Rwanda, one of the most peaceful, prosperous democracies on the continent of Africa, now have gone through a brutal civil time of war. New Zealand, Norway, Spain, to name a few. The plaintiff's submission that the PI is not conducive to a democratic civilian government is factually and materially incorrect and aimed at deceiving the Sovereign Court into accepting their case. This court should not countenance this argument. Second defendant counsel's argument. In his argument, second defendant's counsel did say he would rely on what the first plaintiff has said in addition to what he was saying. In his argument, defense counsel Dr. Emmanuel Safa Abdullah concentrated on the reason why the Electoral Commission was compelled to take the action of advising the president and the fact that the plaintiff's counsel had said that there was no reason, or the reason being very weak. He posited an 8-part test to determine whether the second defendant, the Electoral Commission, acted beyond its powers as follows. 1, whether the Electoral Commission acted reasonably. 2, whether the Electoral had followed due process. 3, whether it is within the limit of that institution to do what they did. 4, whether the decision is national and evidence-based. 5, whether the decision was taken in good faith. 6, whether the decision was published after it was taken. 7, whether the decision served proper purpose. And 8, whether proper consultation was made. He submitted that the decision of the Electoral Commission met all these requirements. Turning to the issue of local government, he submitted that there has never been a law for local government elections, except in the Public Elections Act and through regulations which are made pursuant to Section 23 of the Constitution of Sierra Leone 1991. He concluded that with the new census results, it was necessary to delimit boundaries of constituencies, which the Electoral Commission was unable to do because of the ECOWAS Protocol and Section 18 of the Public Elections Act 2022, which meant that laws for elections must be settled before 6 months to the elections, and to use the current constituencies will be most undemocratic, as it would exclude a lot of people who have been captured by the recent census, which was showing an increase in population of 57,000 plus people spread across various districts and localities. He urged the court to refuse the reliefs. How is it done? The ball is out. Consideration of the issues. The issues to be determined in this case as follows. 1, whether on a proper and purposive interpretation of Section 38A of the Constitutional Amendment Act number 15, 2.1, the controlling provisions stipulated in subsection 1 thereof, namely, what constituencies have not been established are conditions precedent to warrant or justify the holding of general elections of ordinary members of Parliament. By district block system, herein has been referred to as the proportional representation system. 2, whether the directive by the President to the Electoral Commission of Sierra Leone ECSL to hold any public elections for ordinary members of Parliament by the proportional representation system where there are extant and subsisting constituencies is altered by the Constitution Act number 2 as amended. 3, whether the current Parliament was itself elected on a constituency basis as provided for in section 38, 1, 2, and 3 of the Constitution Act number 6 of 1991, and that these constituencies are still extant and subsisting. 4. Whether the revision of constituencies as provided for in section 38.4 does not necessarily result in the establishment of constituencies stipulated in section 38, 1, 2, and 3, but rather the section provides for the period when existing constituencies should be reviewed, which revision may or may not necessarily result in the delimitation of the respective boundaries of existing constituencies. 5. Whether relying on section 38A of the Constitutional Amendment Act number 15/2001 will preclude independent candidates from contesting for Parliament as contemplated in section 77M of the Constitution 1991. 6. Whether the entirety of section 38A of the Constitutional Amendment of 2001 does not provide or contemplate local councils, proportional representation system, elections, and whether the ward basis on which local councils are elected is the subsisting and only lawful basis on which any public elections involving local authorities can be held and not a proportional representation system. 7. Whether section 2 of statutory instruments numbers 13 and 14 dated 16 November making provisions for representation by both members of Parliament and local councils is altered by section 33 and 38 of the Constitution Act number 6 of 1991. I will now deal with these issues serially. Whether on a proper and purposive interpretation of section 38A of the Constitutional Amendment Act number 15/2001, the controlling provisions stipulated in subsection 1 thereof, quote, but constituencies have not been established are conditions precedent to warrant or justify the holding of general elections of ordinary members of Parliament by the district block representation system, hereinafter referred to as the proportional representation system. In the consideration of this issue, one will note firstly that the plaintiffs are arguing that the controlling provision is namely, quote, but constituencies have not been established, and that this is a part of the condition, that this is part of the conditions precedent which must be established, and which has not been established. Hence, the reason why proportional representation at this point in time, when according to them constituencies do exist, cannot be applicable or be the mode or form of elections for the 2023 elections, and by extension, do not justify the holding of elections by such means as adopted via the public announcement, via the press statement of 21st October 2022. This is clearly seen from the plaintiff's argument wherein they have sought to present it thus that as a result of the provisions of section 38(1) of the Constitution Act number 15 of 2001, it would be ultra-vires that provision and unlawful to hold the June 2023 multi-tier public elections in the country via a proportional representation system using the district block system. As they put it, the plain and simple reason that the condition precedent according to them for bringing into effect those provisions in section 38A are, quote, unquote, where there are no constituencies, which at this very moment is not the case in the country, courtesy of the fact that there are extant and subsisting constituencies in operation pursuant to sections 38(1) and 2 of the Constitution. That is to say, the trigger, according to them, to bring proportional representation into operation is, quote, unquote, where constituencies do not exist. And as is explicit to all concerned, there are consistent constituencies existing, 132 of which the plaintiff is the representative or member of parliament for constituency number 77 in the local district. Predicated on the above, the district block representation has already been put into place by the Electoral Commission, will be ultraviolent the very provision which establishes such a system of representation in Parliament, in consequence of which they are seeking the assistance of this court to stop the Electoral Commission from carrying out the district block representation system in place of the constituency-based form of representation which has usually been the case. The defendant's reply is that the plaintiffs have given a very restrictive meaning of Section 38(1) of the Constitutional Amendment, and that Section 38A has never, in fact, provided as they are argued to be the case. They claim Section 38A(1) has not stated or never stated where constituencies do not exist, but that rather that section be read as a whole. To wit, where under any law for the time being in force, the date for a general election of members of parliament has been appointed, but constituencies have not been established in accordance with subsection B of section 38 for the purpose of such election, the President may, after consultation with the Electoral Commission, direct that such elections shall be conducted on the basis of the existing district in a matter to be known as the district block representation system instead of constituencies, unquote. They submit that without the flesh or new delimitation of constituencies after the publishing of census results by Statistics Salone, legally speaking, constituencies have not been established for the forthcoming elections of members of parliament pursuant to section 38A of the Constitution as amended. And that this is exactly the way we have read it, hence the imposition of the district block system. Section 38E of the Constitution Act number 16 of 19 provides, quote, the boundaries of each constituency shall be such that the number of inhabitants here is as nearly equal to the population quota as is reasonable fact, provided that the number of inhabitants of such constituency will be greater or less than the population quota, in order to take account of means of communication, geographical features, density of population, the distribution of different communities, the areas and boundaries of the chiefdoms and other administrative and traditional areas, unquote. The defendants infer from this section that by the words, but constituencies have not been established, is not saying, quote, unquote, but constituencies do not exist, or where there are no constituencies, as the plaintiffs are arguing, but rather that constituencies have not been established based on the current population trend as dictated by the recently conducted census, which does and will always affect population quota and the eventual boundary delimitation of constituencies and the number of constituencies for purposes of elections. The defendants refer to section 38, 6 and 7, which goes on to explain the population quota as mentioned in section 38(3), which is the controlling section as to how such constituencies must be established for purposes of elections. The 2023 elections not being an exception. This is a process which will take time, as explained by the second defendant's counsel in paragraph 11H and 17 of the second defendant's case, and also beyond their control with the recent publication of census results by Statistics Salone. The second defendant on their own had started a review pursuant to section 38(4), but with the population census figures received, it became necessary to establish population quota and the limit boundaries, which was going to take time. And noting the law, section 18 of Public Elections Act number 17 of 2022, and the ECOWAS Protocol on Democracy and Good Governance, supplementary to the protocol to mechanism for conflict prevention and management, article 2.1 under elections, which states, quote, that no substantial modification shall be made to electoral laws in the last 6 months before the elections, except with the consent of a majority of political actors, they will not be able to meet those timelines set. From the above, it is clear to me that there are 2 positions regarding the true meaning of Section 38A and its applicability. This calls for interpretation, and this is what the plaintiffs have sought to invoke by the seeking of the aforesaid declaration pursuant to Section 124 of the Constitution. Interpretation of statutes is the act of discovering the true meaning of an enactment by giving the terms of any enactment its actual or true meaning. As a court, or as judges, we do not interpret arbitrarily, but according to set standards or rules developed over the ages called rules of interpretation. The scope of our work in part of this judgment is to discover, design, or decipher the true meaning of Section 38A as expressed explicitly or implicitly in the language used. Taking the above into consideration as a mandate, I say that on a full reading of Section 38A, it shows the section has 4 parts. Condition precedent. 1. We are under any law for the time being enforced a date for a general election of members of parliament has been appointed. Condition precedent number 2. But constituencies have not been established in accordance with subsection 3 of Section 38 for the purpose of such election. Advised by the Electoral Commission, the President may, after consultation with the Electoral Commission, powers of the President, direct that such election shall be conducted on the basis of the existing districts in a manner to be known as district block representation system instead of constituencies. This court's position is that 1 and 2 supra are conditions precedent. The plaintiff argued that those conditions precedent were not met, while the defendants say they were met. Regarding the first condition precedent, the opposing parties agree that it was met. The evidence is clear before this court that pursuant to sections 57 and 103 of the Public Elections Act number 4, 2012, which was the law for the time being in force, on the 12th March 2022, a proclamation was made by His Excellency the President with the same published on the 14th of March 2022, by which the dates for election of Paramount Chief Members of Parliament and ordinary members of Parliament was appointed as 23rd of May 2023 and 24th of June 2023 respectively. Turning to the second condition precedent, this is where the real dispute exists. The plaintiffs want this court to interpret, quote, but constituencies have not been established to me, quote, but constituencies do not exist, unquote. While the defendants want this court to read, but constituencies have not been established with the connecting words therein to read in accordance with subsection 3 of section 38 for the purpose of such election, unquote. Uncertainty or ambiguity about the meaning of words can arise because of the way words are linked together. This is particularly the case where particular phrases are used. Some of these phrases include in respect of, subject to, in connection with, by reason of, and as in this case, in accordance with, quote unquote. They are nothing more than connecting phrases and indicate some connection or relation between 2 subject matters or sections to which the words refer. The first step or starting point for interpreting statutes, however, despite this provision, which was geared towards the election of members of Parliament and members of Parliament alone, because of the provisions of section 33, which deals with the functions of the Electoral Commission and reads as thus, quote, subject to the provisions of this Constitution, the Electoral Commission shall be responsible for the conduct and supervision of the registration of voters for and of all public elections and referenda, and for that purpose shall have powers to make regulations by statutory instrument for the registration of voters, the conduct of presidential, parliamentary, or local government election and referenda, and other matters connected therewith including regulation for voting by proxy unquote. The then Electoral Commission, being faced with the situation, having known and of having to delimit wards for local council members or councillors, was constrained to put into motion Constitutional Instrument Number 2, published on the 17th of January 2008, titled the Constitution of Sierra Leone Act Number 6, 1991, Wards, Boundaries, Delimitation, Regulations 2008. In that body of legislation, it reads thus: in exercise of the powers conferred by Section 3 of the Constitution 1991, the Electoral Commission makes the following regulations. It is by virtue of these regulations that we now have wards, boundaries delimited for local councils. And this is so despite the seeming restriction of the provision dealing with constituency-based elections for MPs and the delineation of boundaries only for that purpose as per Section 38. The form or format of election was brought about through a subsidiary legislation, and we are unaware that any force was made through this court that a subsidiary legislation was used to effect such change when the guiding provision on constituency-based elections or the main provision guiding did not even mention wards or appear to have considered local councils. In the case before me, in the one sense as regards ordinary members of Parliament, the form of election has been long determined by Parliament, whereas as a result of the presence of the condition in a proportional representation system became necessary as per law established and was approved by the President. With regard to local councils elections, I would say D2. The same has happened as was the case in 2008. While the Constitutional Amendment has not said anything about local councils in Section 38A1, in the spirit of that provision, through their functions as provided by Section 33 of the Constitution, the Electoral Commission, whose mandate it is to conduct and supervise any public elections, have sought before Parliament through a subsidiary legislation to read the laying before Parliament and getting its approval after 21 days through the SI numbers 13 and 14 for a proportional representation system for local councils approved. Should we now, as a court, reject same? I should think not. The word conduct has been seen above is broad enough as to encompass all of this. Firstly, a precedent has been set, which I dare say is not only consistent with the Constitution because of Section 33, but it's on all fours with what Tetsman including leading on to the passing of the boundaries wards delimitation regulation 2008. Second, the Electoral Commission would not be acting outside its functions, which are well stated in Section 33 of the Constitution Act Number 6 of 19, which has been well documented. Thirdly, by Section 32, the level of the Constitution in exercise of these functions, the Electoral Court is not subject to the control and direction of any person or authority. Declaration. All things considered, this court hereby makes the following declarations. 1. That on the proper construction of Section 38A, 1 of Constitutional Amendment of Act Number 15, all conditions precedent for the holding of or conducting of general elections of ordinary members of Parliament through a district block representative were met and or fulfilled. 2. That a directive given by His Excellency the President to the Electoral Commission of Sierra Leone to hold the 2023 elections, public elections for ordinary members of Parliament by the district block representation system instead of constituencies was in tandem with the provisions of Section 38.1 of the 1991 Constitution as amended and therefore not ultra-virus. 3. that the current parliament will soon be dissolved, and thereafter all constituencies currently existing will be extinguished for purposes of representation in parliament in favor of representatives representing each of the 16 districts of Sierra Leone, inclusive of independent candidates who secure the minimum threshold for the attainment of securing of seats in parliament. 4. That the division of constituencies as provided in section 38(4) does lead to a registration of the number and establishment of the subject to parliamentary approval. 5. That independent candidates can and are part of the electoral system and can stand and be voted for to be included in any of the seats representing the existing 16 districts in the country. 6. That statutory instruments number 13 and 14 of 16th November are part of the laws of Sierra Leone and are not altered by section 33 and 38 of the Constitution Act No. 6 of 1991, section 38A of the Constitution as amended in 2001, and section 171 of the Public Elections Act No. 17 of 2001. 7. That pursuant to and subject to the current law in the country, inclusive of the Constitution and statutory instruments number 13 and 14 of 16 November 2002, local council election will be expected to be by district block representations approved as the vote for the 2020 elections. 8. An order restraining the second defendant, the Electoral Commission, its agents, servants, privies, or howsoever called, from taking steps aimed at conducting the 2023 multi-tier public elections on the district block representation system is refused. I say that again. An order restraining the second defendant, the Electoral Commission, its agents, servants, privies, or howsoever called, from taking steps aimed at conducting the 2023 multi-tier public elections on the district block proportional representation system is refused. Emphasis mark. 9. An order directing the second defendant to hold the June 2023 elections for ordinary members of Parliament and Council on a constituency or ward basis is refused. Emphasis mark. Cost. On the issue of cost, this court notes that this is a public interest-based litigation and hence is not inclined to award the usual cost. A minimal cost is therefore awarded in the sum of 3,000 euros to be borne by both plaintiffs jointly and severally payable to the first and to the second. Yes.
May I, on behalf of my client, say we note and take under advisement the 53 odd pages that your Lordship has read out this morning. A judgment that is full of promise and pregnant with possibilities. We will accordingly advise them. May I, before I take my seat, commend the court with respect to say we hope in the future administration of justice in this country, the same alacrity that have been displayed by no less than the Supreme Court in listening case, hearing it, and determining it within 18 days of the conclusions of the arguments and submissions be attended with anticipated to future cases in court to ensure the peace, liberty, and tranquility of our republic. Thank you.
My Lord, once more, on behalf of myself and the team and the defendant, first defendant, the Attorney General and Minister of Justice, we appreciate the judgment and we commend your industry in arriving at such a decision. Just a clarification, my Lord. I am sometimes confused between the new Leons and the old Leons with respect to the issue of costs, my Lord.
New Leons is 3,000.
That is
Old Leons is 3 million.
3 million. Thank you, my Lord. We just want to bring to the attention of this court that this is the very first time the law office has been so industrious without outsourcing, where billions are paid to counsel. This was done amongst ourselves, the new generation in the law office. We thought we were going to appreciate the younger ones, not for self but for others. As my Lord please.
You have to make it fast. One of us is standing.
Just a very short just a statement on behalf of the second defendant. I also want to adopt what Dr. Abdullah said, and I want to commend the court for the swiftness with which this matter has been handled. And I hope that the lower court will be bound by it, not just as advised, bound by it, so that the various judgments that are awaiting delivery are done. The second defendant, my Lord, is very pleased that they can now go ahead with the work of conducting the national elections, which we believe will be free and fair. On behalf of the second defendant, I want to thank you for the very detailed and elaborate judgment, taking into consideration all of the arguments today. Thank you. No, we're not part of the 3 million. You can take it. 3 million is quite enough. It's quite enough for the Thank you.
I second. Thank you.
Of course, we just witnessed the end of the judgment here at the Supreme Court as delivered by the Chief Justice, Honorable Desmond Babatunde Edwards, and as rightly so as declared by the court, the 2023 June 24th general elections shall be held using the proportional representation system, and independent candidates are also expected to be